Hello, my name is Rob Riley, and I'm with the law firm of Riley and Jackson. I've been asked to talk to you today about the process that lawyers commonly refer to as litigation. This is a very common question that we have when clients come into our law office and feel that they need an attorney. The question is always, what should we expect if we go forward? Litigation is the process that our country has that allows people to resolve their disputes whenever they feel like that a matter needs to be brought to trial. Typically, the process begins like this. A client comes into our office and begins to tell us what their situation is, what it is that they're trying to accomplish, and why they feel like that they need an attorney. At that point, what we always try to do is try to resolve the matter with the other party if we can without resorting to having to file a lawsuit. If you can do that, it saves a lot of time, a lot of energy, and a lot of emotional stress. But sometimes that can't be accomplished. Sometimes people have differences of opinions about an issue, and one side feels like they're right, our client feels like that they're right, and the matter simply cannot be resolved without going to court. So our clients always want to know, okay, if we can't get it resolved without going to court, what does it look like if we have to go to court? So that's what I want to talk to you about today. The process of litigation, if you go to court, goes like this. We sit with our clients and we get all the facts, and we look at the facts, and then of course we look at the law to make sure that we have a valid claim that we can bring. If we don't feel like that there's a valid claim, even if someone feels like that they've been wronged, then we tell our clients, we're sorry, we know you feel like that you weren't treated fairly, but there's nothing that we can do for you. But if we feel like our client is right, we proceed with filing a lawsuit. Legally, that's called a complaint. After the complaint is filed, it takes usually a couple of weeks to get service on the adverse party, known as the defendant, and then the defendant has 30 days to respond to the allegations in the complaint. At that point, typically another lawyer shows up for the other side, and that lawyer will draft a document, they call it an answer, that answers the allegations. The lawyers talk. We always try again to try to resolve the case as quickly as we can, as early as we can, because we find that that's in the best interest of our clients. If we can't resolve it, the next stage is typically interrogatories and depositions. An interrogatory is a written question. We send written questions to the other side. The other side sends written questions to our client. And we sit with our client. We answer those questions. We send them back. If that still does not help get the matter resolved, then we move to the deposition stage. A deposition is simply where all the parties get together, the attorneys get together, and sworn testimony is taken. So a court reporter shows up. We get to ask questions of the adverse party, and then the attorney for the adverse party asks questions of our client. And it's all typed. You're sworn to tell the truth, and the court reporter takes down the testimony. Sometimes that process helps resolve disputes because we've learned that sometimes just a client being able to tell their side of the story to someone, even if it's the attorney for the other side, helps bring things to a closure. If it still is not resolved, many times these days, the parties will then agree to go to a mediation, or the court will order the parties to go to a mediation. A mediation is a process where all the parties get together and the attorneys get together, and a neutral person who is typically a former judge or an attorney comes into each room individually. Our clients and the attorneys and ourselves are in one room, and then the adverse party and their attorneys are in another room, and the mediator talks to everyone, and tries to make sure that everyone recognizes the strengths and weaknesses of their cases and tries to bring the parties together to try to reach a resolution. If a resolution still cannot be reached, then the next step and the final step of the process of litigation is the trial. You can have a trial with just a judge, or you can have a trial with a jury. The parties get to decide if they want a jury or not. Once you go to trial, you get to present your evidence. The attorneys, the plaintiff, goes first and presents their side of the facts, and the lawyers get to argue as to and explain to the jury why they feel like that their side is correct. After the plaintiff gets to present their evidence, then the defendant gets to present their evidence. Now, during the process, even when the plaintiff is presenting the evidence in support of the plaintiff's case, of course, the defense lawyers on the adverse party side get to cross-examine the witnesses. So each side is tested, the evidence is tested all through the trial. So if we back up just a little bit, the trial starts with an opening statement. The attorneys get to stand up and tell the jury what to expect. Then the plaintiff gets to put on witnesses. The plaintiff's attorney gets to ask those witnesses questions. And then the attorney for the defendant gets to cross-examine those witnesses. After that, after the plaintiff has presented all of his or her witnesses, then the defendant gets to present his or her witnesses. After all of that has taken place and been completed, then the attorneys get to make what they call their closing arguments. This is their final pitch. This is their time to come in and tell the jury why, based on the facts and the law, their side should prevail. The jury then gets to take that information and go back into the jury room and deliberate. A foreperson is chosen. In Alabama, a verdict has to be unanimous. If a jury cannot reach a unanimous decision, then the judge will declare a mistrial. But the judge really encourages the juries to try to come to a decision, to try to reach a verdict. And in a very, very high majority of the cases, the juries do just that. They reach a verdict. After the verdict, that is the final say of the case. Each side has the opportunity to appeal if they want, but at that point, the jury has spoken, or if no jury, the judge has spoken, and that is the way that parties resolve their disputes through the process of litigation. We've handled thousands of cases, and if you have any other questions about this process or would like to talk about it, we would be more than happy to talk to you.